Is wow. Wow. This week was a blockbuster week for the United States Supreme Court. It released several cases this week that forever changed America. We're going to talk about it because this six conservative majority is having a big impact on this country already. And what we're going to look at is how they have already impacted the African American community. So don't you go anywhere. You come back. Stay with us so that you can learn this and see what we're seeing. This is critically important.
That Corbin and Corbett legal team fighting for the rights of the people. That father-daughter team investing in the youth when the system ain't treating them equal. Providing truth for our people, we able to reach them. So anytime you get accused for a crime and Lord knows you ain't do it, we here to get you through it. Exemplifying prudence and glorifying God, making sure you're compensated for other people's doings. Our vision is to be one of the best. We're small enough to focus on your matter throughout the neighborhoods of Dallas. Working constantly and making sure your rights are protected. A firm team of lawyers, aggressive, effective. A team that has your back in the courtroom. Two well-spoken black lawyers in the courtroom. Investing time and resources when it's evident that you were treated wrong. Now you walking out of Dallas courtroom with a settlement. Corbin and Corbett, the father-daughter legal tag team that has your back in the courtroom. Our purpose is simple. To obtain the favorable outcome for each client and glorify Christ in all we do. Our vision is to be one of the best and most...
What is up, everybody? What is up? Happy Saturday. This is Attorney Augustus Corbett, a.k.a. the Minister of Justice, and with me I have
Attorney Chloe Corbett, a.k.a. the Duchess of Justice.
And we are father-daughter legal team who provide legal analysis of trending politics, policies, personalities, and pop culture to empower you with information you need to be a legal rebel. If you're not a subscriber, please like, share, and comment. And thank you again for tuning in to today's broadcast. This is an important broadcast because, again, the United States Supreme Court, especially that six majority conservative court, is showing up in a big way. And we're going to discuss three of their most important cases today. We're going to discuss a Miranda case that they did. We're going to discuss, let's see here. Okay, I think we got some, because we were just having technical difficulties. Okay, they're still saying yours is not as crisp as mine, but it is what it is. We're going to have to go forward with it. But anyway, there are three cases that we want to talk about today that the U.S. Supreme Court handed down last week, and they are big cases, Chloe. The first case, Vega versus Teka. Second case, Dobbs versus Jackson's Women's Health Organization, having to do with abortion. And the third case is New York State Rifle and Pistol Association versus Bruin, has to do with gun rights. The first case has to do with Miranda. So these cases are huge cases. And we're not going to do a really deep dive into these cases because we would get, over people's heads with the legal analysis. Both the abortion case and the gun case are like 100 pages of both a majority opinion and a dissenting opinion. In fact, let me explain to you, when the court hands down these cases, one person writes the majority opinion, one of the people in the majority. And then typically someone from the minority will write a dissenting opinion. And then Someone in the majority may write a concurrent opinion, and it's good to read all of them. Of course, the majority opinion is what becomes law, but the dissenting opinion will kind of lay some framework for what could happen in the future, and the concurrent opinion just kind of brings a different sort of perspective to the majority opinion. And as lawyers, we enjoy reading all of it. When I heard about these cases, I told my wife, I can't wait to stick my teeth in these cases. They were like big, juicy, dripping steaks sitting out there just waiting for me to just, Chloe, just to eat them up. But and they were good. I read them, except for the abortion case. You're going to talk about that, and I'm going to kind of sit back on that. I think the last thing some of these pro-choice folks want to hear today is some man's opinion about abortion. So I'm going to kind of just sit back and let you handle that. So let me throw it over to you. How you doing today?
I'm doing so well, Dad. Thank you. I'm glad to be here. There really has been a lot that's come out from the Supreme Court. It is trending all over this country, all over the world. There are now protests, especially in regards to the abortion case that I'm going to discuss. This is really going to, I believe, change the political landscape, especially as we go into this year's midterm elections, as well as the presidential elections in 2024. So these opinions are going to ripple across our nation for years to come. So I guess I'll get into talking about the abortion case. I'm going to let our readers know, or our listeners know, that I have my iPad here. I read a large majority of this opinion on my iPad, and I took notes. So if I'm looking down at my notes, because there is a lot to digest here. This is a 200-page opinion with a large portion of it being a majority opinion, like my dad said. There are several concurring opinions, as well as dissenting opinions from the 3 liberal justices who dissented against this decision. So there's a lot to break down and a lot to go through. So I'm
going to kind of sit back, Chloe, as you take care of it. But I do, before you get started, I wanted to acknowledge several of the legal rebel community. Of course, your mom, sweetheart, how you doing? And I see an old friend, someone who started with us from Israel, Connie Cachette. She's back with us. You remember Connie?
I do.
Yeah, she's back with us. Welcome. Thank you for joining with us again today. And let me just read her comment. She says, quite a shock. Even in Israel, Facebook has Hebrew comments on the abortion ruling. Shock. In a country without universal health care, in a country without paid maternity and sick leave, country with highest death rate for pregnant moms, well, let's just encourage more deaths, she says. So there's her feedback on this case. So take it over.
Thank you for that comment, Connie. We appreciate it. And thank you for everyone else who is listening and who will listen in the future. So the name of the case, let's start with that, is Dobbs, State Health Officer of the Mississippi Department of Health, et al., versus Jackson Women's Health Organization, et al. That is the name of the case that the Supreme Court issued and decided yesterday, June 22nd, 2022. After hearing arguments last December 1st of 2021. And, a lot of this is not a shock for a lot of people, because there was a leaked draft of this opinion that came out a couple of months ago, and it predicted, based on that leaked draft, that the Supreme Court would do this and make this decision. And at the time, it was a huge shock. A lot of times, those drafts that circulate between justices and their offices and the clerks that work for them are not leaked, because the Supreme Court has been seen as a very serious court, a very high level and elite institution. So the fact that the memo was leaked was huge in the legal world and across the nation. But we knew that this was coming, and it finally came out yesterday. So I'm going to give the court's ruling and conclusion first, and then I'm going to walk back and go into a little bit of the reasonings why the court made the decision that it did. And it's important to again highlight what you said at the beginning, that this is a 6 conservative majority justice with 3 liberal justices out of 9. So there are 6 conservative justices and 3 liberal justices, and that makeup of the court has never been seen, to my knowledge, as it has in this current era of the court. So basically, the court held that there is not a fundamental, substantive due process right for a person to have an abortion. Instead, abortion laws and rights must be mandated on a state by state basis.
So that's the basic holding of the case.
That's the basic holding of the case.
Could you? I know you're going to explain it, but could you just state that again?
Yes, that Americans do not have a fundamental, substantive due process right to abortion. Instead, the abortion must be decided on a state by state case. So the state legislatures, who are elected by citizens of that state, should have the right to decide abortion laws for each state's citizens, instead of there being a fundamental constitutional right to have an abortion.
Okay.
That is basically what the Supreme Court decided.
Okay.
And just to go into a little of who the players are. So the respondents, the ones who were responding to this appeal, were Jackson Women's Health Organization, as well as a doctor. So there was a health
organization. Were those the people who were providing the abortions?
Yes. Mm-hmm. The Jackson Women's Health Organization was an abortion clinic in Mississippi.
Do you know if that clinic was a part of Planned Parenthood?
I don't know if it was a part of Planned Parenthood. I don't believe it was.
Okay.
I do know.
It would say that, right?
Yeah. I do know that this was the only abortion clinic in Mississippi, according to reports that I read.
Okay.
So out of the entire state of Mississippi, the Jackson Women's Health Organization was the only one that provided abortions.
Okay.
And they challenged a Mississippi law. So this is a Mississippi case that is a challenge of a Mississippi law. And the Mississippi statute said that a person shall not intentionally
Let me interrupt you again. Let me make sure everybody understand. So the abortion clinic, you said, are the respondents or the petitioners?
And for this Supreme Court case, they're the respondents, but they were the petitioners to challenge the Mississippi statute.
Okay, so then, and who did they challenge?
They challenged the lawmakers who drafted the Mississippi statute.
All right, so those lawmakers apparently won at the Court of Appeals level, right?
Yes.
And is that right? I mean, and then the Jackson, Mississippi, and then the abortion clinic appealed that to the U.S. Supreme Court?
Yes, and the court granted certiorari because of that.
Granted certiorari?
Yeah, excuse me, certiorari, yes.
Okay. All right, go ahead.
So, this abortion clinic is the only clinic in Mississippi that was providing abortion. There was a new law that Mississippi enacted that stated a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. So that is a new law that the Mississippi legislature enacted. And so the Jackson Women's Health Organization, which, as we established, an abortion clinic, and one of its doctors challenged that new act in federal district court. And
So,
they challenged
so there
it.
couldn't be abortions after 15 weeks.
Right. Because they're saying that this violated Roe and Casey
Yes.
because it was more restrictive than what Roe said, which was the viable period, which I believe was 15 weeks, if I'm remembering correctly. Do you remember what the viable period was that Roe established?
And
I think it was-
Casey, both of those cases. And I think it was 24 weeks. I think it was I think you could not abort a child in the last trimester.
Okay.
So that would have 9 weeks typically, right?
Yes.
And yeah, I'm getting a little confused with the weeks, but the first 2 trimesters under Casey and Roe, a child could be aborted, but that final trimester, if I recall, states could interfere and burden abortions for that last trimester. So what would that leave? 24 weeks is in my head for some reason. Yeah, that's it. 24. So after the 24th week, states could interfere with abortion. The first 24 they couldn't, because that's I'm sorry, I'm getting the weeks confused. So 9 weeks of pregnancy, the last trimester would be those last 4 weeks.
No, that would be I'm getting confused too now. I thought viability was around the 16th week, but again, I could be wrong.
No, it's later than that. It's later than that. Somebody just texted and said it's 28 weeks.
Okay.
I have 24 weeks in my head for some reason. Obviously, I've never had a baby, so I'm not certain about all that. But that last trimester is the period of viability.
Right. So this abortion clinic and its doctors challenged this law because it banned abortions after 15 weeks with few exceptions, and none of those exceptions involved cases of rape or incest. So the Jacksonville clinic and one of its doctors, like I said, sued Mississippi officials in federal court, saying that the state law was unconstitutional. And in fact, the abortion clinic and the doctor, they won at the state level. The district court granted summary judgment in favor of them, in favor of the respondents, and they permanently enjoined the state from being able to enforce the statute that they enacted in 2018.
Okay.
So they won. Obviously, the state of Mississippi, they sued all the way up to the Supreme Court. And that's where the petitioners defended their statute by saying that Roe and Casey were wrong, and that the act is constitutional. So,
go ahead. I'm trying to follow you and trying to make sure everybody else follow, because this is complicated.
It's complicated. So Mississippi officials said that Roe and Casey it was completely wrong. So that therefore the statute that they enacted, the law that they enacted in Mississippi is constitutional, because Roe and Casey were fundamentally wrong.
That's the
clinic,
Fifth Circuit, right? That's the Fifth Circuit, right? Mississippi, I believe, is in the Fifth Circuit, which is a very conservative circuit.
That's right. That's right. So those are the fundamental differences between the petitioners and the respondents. The petitioners, the state of Mississippi, said that Roe and Casey were wrong, therefore their law is constitutional. The abortion clinic and the doctors, they said that this law violated the viability period that had been enacted by Roe v. Wade, and also it was a violation of the fundamental right of women to have abortions.
So, so the abortion clinic won at the lower level in district court, right?
That's right.
And then the state of Mississippi appealed to the Fifth Circuit?
Yes. And the Fifth Circuit affirmed that the abortion clinic was able to win.
Wow, first of all, that is surprising. So the Fifth Circuit sided with the abortion clinic against Mississippi's new abortion law.
Yes.
All right, and so then the abortion clinic appealed that decision, and the court granted certiorari, and that's how the case ended up in front of Scotus.
That's right.
And the abortion clinic essentially, because Mississippi, and I remember when that happened, states, conservative red states, began to enact laws, very restrictive laws against abortions during Donald Trump's presidency. Mm-hmm. And so they essentially said that, like you said, Casey, Roe are wrong, and you cannot abort a children early on, like 15 weeks instead of the 24 weeks of Roe and Casey, essentially. And I might point out here in Texas is even more restrictive, all of it now is kind of washed away since this opinion has come out. But before this opinion came out, Texas was even more restricted than Mississippi, and essentially said as soon as you could detect a heartbeat, you couldn't abort a child. But in Mississippi, the law was you couldn't abort a child after what'd you say, 16 weeks?
15 weeks.
15 weeks. Okay. All right. So the court decided to hear that case. And by the way, it only takes 4 of the justices to hear a case. It doesn't take a majority. Only 4 is needed to grant certiorari.
And so a lot of the argument back and forth between Mississippi State and the abortion clinic, and a lot of what the court focused on in its analysis and its opinion, is whether or not the right to have an abortion is a fundamental right under the 14th Amendment specifically.
Mm-hmm. Okay.
And I want to read the 14th Amendment to our audience. I'm trying to pull it up on my phone. Excuse me one moment.
Okay, I'm pulling it up too. I have it actually. You want me to read it?
Yes.
The 14th Amendment says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. No state shall make or force any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Wow. I see exactly where that's headed.
Mm-hmm. So that last couple of sentences that you read, Dad, that is the basis of litigation on abortion rights,
Let me read it again.
Yeah. Mm-hmm.
Nor shall, we'll start with nor.
Yes. Mm-hmm.
Nor shall any state deprive any person of life. Is that where they hung their hat? Deprive
Not
any
life.
person? Oh, not life, okay. Deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws.
Liberty.
Okay.
Liberty. That is the disputed word.
Okay.
That is where the Supreme Court focused most of its analysis.
Okay.
And that is where the Supreme Court said that under the definition of liberty, of our right to pursue not just life, liberty, and property, but the liberty part, that the right to an abortion is not a fundamental part of our liberty under the 14th Amendment. And specifically, the Supreme Court said that...
You said the right to property?
No, liberty.
Okay, all right. Liberty is the due process interest here that's being litigated.
Yeah. I was just pointing out to the audience, the 14th Amendment says life, liberty, or property.
Okay.
But the Supreme Court focused on liberty.
All right.
And the Supreme Court said the Constitution makes no express reference to a right to obtain an abortion, but several constitutional provisions have been offered as potential homes for an implicit constitutional right. Okay? So the Supreme Court said that Roe held that the abortion right is part of a right of privacy that springs from the First, Fourth, Fifth, Ninth, and 14th Amendments. That wasn't the issue here, because a later case came back and said, well, no, abortion right is not a fundamental right under a right of privacy. But the Casey court held its decision on the theory that the right to obtain an abortion is part of the, quote, liberty protected by the 14th Amendment due process clause.
Okay.
So essentially, Casey came in, which was another abortion case that was decided by the Supreme Court, and said, well, no, it's not just that citizens have a right to privacy, but a woman has a right to get an abortion under the liberty portion of the 14th Amendment. The Supreme Court, in this opinion, said no. The right to an abortion does not fall under the liberty provision of the due process clause of the 14th Amendment. Okay.
Now, I know Roe also said something about a right of privacy based on the penumbras of the Constitution, which conservatives would often say, where's that? What are you talking about? That's not in the Constitution. And that's where a lot of women argue that their right to, and this is Roe, this is not Casey, but this is primarily Roe, that their right to an abortion is a privacy right. It should be a right that they and their doctors decide, not the government.
That's what Roe said, but the Supreme Court, in this opinion, kept referring back to Casey, the second case.
Okay, yeah.
Big case about abortion rights, and said that, look, we basically agree that there's no right to privacy for under Roe to an abortion. So let's focus on Casey.
No, Roe said there is a right of privacy.
I know, but the Supreme Court was saying, because Casey focused on the abortion right being a liberty right under the due process clause, we don't even really have to address the right to privacy under Roe.
Okay.
Because of Casey.
Yeah, all right.
Does that make sense? I don't want to get too detailed, because
yeah, we don't. We're going to move on here in just a minute. But I guess the court was saying Casey was the last case we decided. Well, then after Casey, I think there was Webster. But Casey, well, maybe there was Roe, Webster, then Casey. But I think Casey was the last one, and so they were, dealing with the most recent case, basically.
Yeah. And to that point, in this opinion, the Supreme Court said that when Casey revisited Roe almost 20 years later, it reaffirmed Roe's central holding, but pointedly refrained from endorsing most of its reasoning. The court abandoned any reliance on a privacy right, and instead we grounded the abortion right entirely on the 14th Amendment due process clause.
Okay. So listen, bottom it out for us.
Bottom it out. Abortion right. There's no fundamental right to have an abortion anymore.
What does that mean?
There's no so in the Constitution, there's certain fundamental rights that we're born with under the Constitution.
Okay.
The right to bear arms. Okay. The right to freedom of speech. The right to protest.
Okay.
They fall under the first 8th amendments of the Constitution. then there are other fundamental rights that the courts had to decide, like the right to marry a person of another race.
Okay.
That right is not listed in the Constitution.
Okay.
However, the court came in under Lovin v. Virginia and said that U.S. citizens have a fundamental, substantial right to be able to intermarry between races.
Okay.
Under Roe v. Wade, the Roe Supreme Court said that there was a fundamental right for a woman to have an abortion.
Okay.
Even though it's not listed in the Constitution, it's still a fundamental right under, our pursuit of life and liberty, etc.
Okay.
So this Supreme Court said that we don't have a fundamental, substantive right to an abortion. One, because it's not listed in the Constitution. And two, when you define what liberty is meant throughout our history, abortion was not one of them. And in fact, the court goes into a lot of detail how abortion was criminalized. It was a criminal offense to get an abortion back in the 1800s.
Okay.
So because of that, the Supreme Court said, basically, it is up to the states and the state legislatures to decide abortion rights and how they want to control it.
So in my head, what I'm hearing you and the court say here is you can't look to the U.S. Constitution and argue that you have a right under the U.S. Constitution to get an abortion. You're going to have to get that done under state law, not U.S. constitutional law.
Right. Unless the U.S. Congress comes out with a federal abortion statute.
Well, we know what's going to happen with that. If they do that, right, somebody's going to sue, and that's going to end up back in front of this 6-person majority, and they're going to strike that down.
Yeah. So basically, abortion is controlled by the states. So Texas can do something different from California, which we've already seen. California has, in fact, is in talks of expanding its abortion access, versus Texas. They have a trigger statute within 30 days of this decision. They're going to outlaw abortion, and except for a couple exceptions, like we said before, versus New York is going to do something else. So it's on a state-by-state basis and case.
Now, you said a trigger statute. What is that? What do you mean?
So state legislatures, I think about 7 states, so they enacted laws that said if the Supreme Court comes out with a decision that is going to trigger our abortion laws to be enacted. So I believe Missouri, and I think it's Missouri, it was already triggered. So as soon as this opinion came out, abortion was banned in Missouri.
Okay.
And then I just saw that the Oklahoma governor just signed an abortion law as well.
What about Texas? I think Texas had a trigger statute as well, didn't we?
Yes, but it doesn't start for 30 days from what I read.
Okay. All right.
So it's not automatic.
Okay. Well, you and I could talk about this for days. It's fun to us to talk about liberty interests and Fourth Amendment interests and due process and equal protection rights and all of that. And the court process and procedures and so forth. But we may bore the audience with all of that. Could you once again just recap what this case means for women in America?
This means that women in America do not have there's no fundamental right to abortion. That abortion access is now controlled by your state.
Okay.
There's been a lot of questions too about, well, can women travel to another state to try to get an abortion in another state? From my research, there are no laws that I've seen that criminalizes a woman crossing state lines to get an abortion in a state that allows it. But I wouldn't be surprised if some of these state legislatures, do enact codes to make it a criminal offense to travel state lines. So we'll see.
Okay.
And another thing I want to address.
All right.
There's just so much to this. I didn't even scratch the surface. But another thing I want to address that I've seen is causing a lot of people concern is the concurring opinion by Justice Clarence Thomas.
Okay.
because in his opinion, he said that we should address Griswold and other cases, which is, Griswold was for that granted same-sex marriage, and then the right to contraceptions and other issues like that. A lot of people are concerned that the Supreme Court is going to use the reasoning in this case, basically being that because abortion or gay marriage or contraception is not listed in the Constitution, that means that there's no fundamental right to it. So it needs to be overturned and let the states decide it. So that's causing a lot of concern and debate based on his concurrent opinion. So I wanted to bring that out as well.
Yeah, the Griswold case dealt with contraceptions, and I think, if I remember correctly, the homosexual case that basically held that homosexuality cannot be criminalized was the Lawrence v. Texas case that Justice Anthony Kennedy wrote some years ago, 2000 something, maybe 2005, maybe. That is something. So Justice Thomas is suggesting that contraceptions shouldn't be a fundamental right as well, and nor should homosexuality. So
that the state should decide it.
That the state should decide it. There's no fundamental right to either or in the U.S. Constitution. All right. So that is the conservative majority. That more than anything shows you that elections have consequences. And there you go. Now notice, neither Chloe nor myself expressed our personal opinion on abortion or Roe. We're just telling you what the law says. Okay? All right. So, Chloe, I guess we'll go to the next case. And let me see. I guess we'll look at the Miranda warnings case. All right. And I guess I'll deal with that one. So in our country, if a person gets arrested, well, they don't have to be arrested. If a police officer, law enforcement, has someone in custody, and Chloe, help me out, has someone in custody, Chloe was the prosecutor here, has someone in custody, and then starts interrogating them or asking them questions. Before they started asking questions of a person that they have in custody, in many cases have tried to have interpreted what that means. It doesn't necessarily mean arrest. You don't have to be arrested. But it does mean that you feel like in your mind you cannot leave. So if you feel like in your mind, reasonably believe you cannot leave, and the police is asking you questions, under the Miranda case, the police is required to give you Miranda warnings, which are, you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to an attorney. If you can't afford one will be appointed. So that is based on both the Fifth and the Sixth Amendment. Fifth Amendment, in that you cannot be forced to self-incriminate. In the Sixth Amendment, and it's not quite a Sixth Amendment argument basis, but the Sixth Amendment deals with your right to counsel when you're facing adversarial judicial proceedings. And actually dealing with the police is not, the court said that's not adversarial judicial proceedings. So it's really not a Sixth Amendment issue. It's really more of a Fifth Amendment issue. But at any event, when Chloe and I are representing people who've been arrested, that is one of the first things we want to know. Were you in custody, and were you being interrogated? Were you being asked questions? If so, did they read you your Miranda warnings? And because if not, sometimes we can get whatever was said thrown out of court. We can get it suppressed. And if that's the only evidence the state has, quite often we can get cases dismissed if we can reach that high burden of showing that the state or the police officer, the state, what have you, violated your Miranda rights of getting warned if they had you in custody and were interrogating you. So this case, the Vega versus Teco case, let me put it back on the screen, implicates Miranda warnings. And essentially what happened here, this Vega is the name of a sheriff deputy from Los Angeles County, and Teca was a person who was accused of sexually assaulting someone. And Teca eventually basically sort of admitted to doing some things, but he argued at trial that Deputy Vega had not read him his Miranda warnings. And so essentially after a couple of trials, the jury found Teca not guilty, okay, because they had problems with the Miranda warnings. And so his criminal case was done away with. But then he sued Deputy Vega on the basis of a 1983 claim. Essentially, and let me explain what a 1983 claim is. 1983 is a section of federal law. It's really 42 USC 1983, and it's where citizens of the United States or persons here in the United States can sue law enforcement if law enforcement violates their constitutional rights under color of law. So like George Floyd's family, Walter Scott's family, and other families, and we're holding some police officers accountable for the same thing, can use Section 1983 to hold police officers, or at least to try to hold police officers accountable in civil court. And I want to make that distinction, civil court versus criminal court. And basically, the U.S. Supreme Court said that Teca could not sue Deputy Vega under 1983 if he didn't read Teca his Miranda warnings. Essentially, the court said that Miranda warnings are not a constitutional right. And it's weird. It's a weird opinion. When I read the opinion, I'm like, whoa. It's like it was written by Justice Alito, and I think Justice Alito also wrote the abortion opinion. He was twisting the opinion, trying to reach his conclusion. He knew the conclusion that he wanted, and it was like he was twisting it because first-year law students know that Miranda is based on the Fifth Amendment, which is a part of the U.S. Constitution. So he was saying that Miranda is basically prophylactic rules which don't have the same importance as a constitutional right, just rules to protect a constitutional right. And so since in his reasoning and the majority's reasoning, Miranda warnings are mere prophylactic rules that are not constitutionally protected, then Teca could not bring a 1983 lawsuit. All right, now let me just talk about that a moment. So again, Section 1983 lawsuits are brought by people who believe law enforcement violated their rights, their constitutional rights. For example, if a police officer uses excessive force, then you can sue them pursuant to 1983. If they conducted an unreasonable search or seizure, you can sue them under 1983. Up to this point, if they didn't read you your Miranda warnings, you could sue them under 1983. But the court said, nope, not anymore. You can no longer sue a police officer under 1983 if the police officer failed to read your Miranda warnings, because Miranda warnings are not constitutional rights. That is the essential holding of this case. Now, I want to make something really, really, really clear. The holding in this case does not affect criminal cases. So, if Chloe and I got a client, someone calls us and says they were arrested and Miranda warnings were not read, we will not consider this case Vega v. Teca in our analysis in defense of our client who did not get their Miranda warnings read to them, although they were in custody and being interrogated, because the Vega v. Teca case, again, has to do with civil lawsuits, not criminal cases. So a person still has Miranda rights despite this case. That is really important. So police officers still have to read a person's Miranda warnings if they are conducting a custodial interrogation. If they fail to do so, we still may be able to get the case kicked out of court, but the defendant cannot sue the police officer. That's basically what that means. How did I do, Chloe?
Did great. They're absolutely great. And I think making that distinction between what happens in a person's criminal
put the mic
case,
a little bit closer to your mouth.
I think, is this better?
Yeah.
Yeah, I think making that distinction between what happens with the criminal case, that everything stays the same, that if a person is in custody or arrested, they still have the right and must receive those Miranda warnings before the police interrogate them and or ask them questions. The issue, though, is for civil rights attorneys like us, we know every day that, you know, our clients' civil rights are violated by the police. So now this is something that is taken out of our bag of claims against the police if we're going to sue them for violating our clients' constitutional rights. So that's an unfortunate result of this opinion. We have several cases now where this could apply to one of our cases, to some of our cases. And now, because of this opinion, we cannot use that to say that our clients' constitutional rights are violated. So,
well, let me make a distinction, because the court specifically said in the opinion that a failure to read Miranda warnings when it was appropriate and required can still be based on 1983, but you just can't argue that it was a constitutional violation.
Okay. So you still can't use it as a cause of action with the 1983 case. You just can't say it was
depends on the facts and circumstances. It just depends. You just can't say that we're bringing this case on the basis of the Fifth Amendment.
Okay.
So I wanted to clarify that. Because I think I did earlier say that you couldn't bring it at all, but I want to make sure I'm bringing out a nuance that Justice O'Leal pointed out in the opinion, that a failure to read a Miranda warning type case could potentially still proceed under 1983, but not on the basis of it was a constitutional violation.
Okay. That's still a good, I mean, they're trying to make that distinction, but I don't think they should have. I don't agree with this ruling.
Me neither. I mean, what I don't understand is, again, a first-year law student knows that Miranda warnings are based on the Fifth Amendment. So how can they say that Miranda warnings are mere prophylactic rules, and they are not a constitutional protection. I mean, if a police officer it conducts a custodial interrogation and violates and causes someone to self-incriminate, we can get those cases thrown out of court. We've done it.
Yeah.
So that to my mind, that is a Fifth Amendment constitutional violation. And that was also what the dissent wrote. Justice Kagan wrote a dissenting opinion where she said what I'm saying, and I think so many people are saying it. Justice Alito, what you're saying doesn't make any sense at all. It sounds like you're trying. It sounds like to me, and he did this also, with all due respect to Justice Alito, but he did this also in the Brnovich voting rights case, where they gutted Section 2 of the voting rights. It sounds like they have a certain result that they want, and then they stretch things and twist things to get there.
Yeah.
I hope that's not disparaging to, Justice Alito and the conservatives on the court. That's not what I'm intending to do, but that's what I was thinking as I was reading this opinion in the Brnovich opinion that Justice Alito wrote.
Yeah, and specifically, the Fifth Amendment says a lot, but the portion that we're referring to is no person shall be compelled in any criminal case to be a witness against himself, nor be deprived of any life, liberty, or property. So when you receive those Miranda warnings after you're in custody and before interrogation, that's what it is informing you about, that, you have the right to an attorney. If you can't afford one shall be appointed to you. Anything you say can and will be used against you, etc. It's warning you that if you say something, this could and will likely be used against you in a criminal proceeding. And another thing, I mean, it's the job of the judges in the Supreme Court to interpret what the Constitution and what the laws say. So are they saying that their interpretation of the Fifth Amendment is wrong? I don't know.
Let me explain what they're saying. I understand what they're saying. I just disagree with it. Let me explain it. All right. So thank you for reading the Fifth Amendment. I think that is very helpful. Could you read it? Could you read that portion again?
My iPad just died.
Oh, all right. I don't have it here, but essentially it prohibits the government from forcing someone to self-incriminate.
Yeah.
All right. So let's think of several scenarios. Let's suppose a police officer puts a gun up to somebody's head and says, "What did you do?" That's obvious coercion and forcing someone to confess, right?
Mm-hmm. Yeah.
Right or wrong?
Right. Yeah.
All right. So that's obvious. All right. So that is a clear violation of a person's Fifth Amendment right. All right. Let's distinguish that from the police officer being required to say to someone, "You have the right to remain silent. Anything you say can and will be used against you in the court of law." That is a rule that the court requires of law enforcement. So the majority is saying by not reading or stating that rule is not the same as if law enforcement forced someone to self-incriminate. Does that make sense?
Yeah.
The rule is based on the Fifth Amendment, but the rule is not the Fifth Amendment.
But it's their interpretation of the Fifth Amendment.
It is their interpretation. It is what is needed to protect the Fifth Amendment.
So because of it's their interpretation of the Fifth Amendment, to me, it is a constitutional right, because that's what they interpreted the Fifth Amendment to mean.
I agree. That's what they interpreted the Fifth Amendment to require.
Yeah, to require.
Yeah, I agree. And the dissenting justices, Kagan, Sotomayor, and Breyer, they agreed.
Yeah.
And, you know, but before folks really run with this and start saying, hey, we don't have a constitutional right to not self-incriminate, or Miranda was struck down. Miranda was not struck down in the criminal context, in the criminal case context. Just there will be problems trying to use it in a civil lawsuit based on U.S. 42 U.S.C. Section 1983. All right, let's go to the next one.
We have some comments here too.
Please read them.
So we have a lot. Connie made some comments. She said, "Thank you for being careful and clear. Thank you." Connie complimented you and said you would make a great teacher, Dad. Maybe something, be a professor. Yep.
Thank you.
No None said.
Let me just say, constitutional law was my favorite course in law school. I loved it, still to this day.
No None said. So basically, they're saying you have rights, but we are not obligated to inform you of your rights.
Oh, I like that. I like that. Well, what they're saying is that it's basically not a constitutional violation if they don't inform you of your rights. Therefore, you can't sue the officer. You still may be able to get the case thrown out in a criminal court, but you won't be able to sue. Not on the basis of it was a constitutional violation. There may be some other reason why you can proceed with your Miranda warning 1983 case.
Yeah, that's a good distinction.
Yeah. Okay. All right. So, you ready to move on?
Yes.
Thank you all for those comments. All right, the last case. And we don't have a lot of time because we're trying not to be up here 2 hours, even an hour and a half.
One thing, I'm sorry, Dad, we do have a new rebel, Jorge Oliveira, who's from Portugal. So, hi, Jorge.
Oh, wait a minute. There is something I like to do when somebody's new. Yeah. All right. So thank you, Jorge. Okay, so the last case that we'll look at here is the New York State Rifle and Pistol Association versus Bruin. Has to do with the Second Amendment. All right, so let's talk about it for a moment. So this case, there's some Facebook comments too, Chloe. Before I get started, let's recognize those comments, okay?
Okay. Let me pull them up.
I don't see them. Speaking to your mic though, when you got your head turned, nobody can hear you.
So Ava Aldris says, it's just the truth. These guys are stretching the truth to meet their desired outcome. Lord have mercy. I think that's in reference to your explanation of the Miranda warnings.
Okay. I completely agree with Sister Ave.
And then Sister Ave also said, this is again an opportunity to minimize the accountability of police officers.
Amen. Let me just comment on that, because that is essentially what this is. I mean, the conservatives are, pro law and order, and we all are, but not to the degree that you get rid of accountability, because then that becomes dangerous, especially for minorities.
Yep.
So, yeah, they basically want a police state. The police can do whatever they want to do, basically. And you got to, thank God for the invention of cell phones.
Yeah.
Because if it wasn't for cell phones capturing some of these 1983 violations, we wouldn't get justice most of the time. A lot of time, some still don't get it a lot of times, even with video. I remember the Rodney King. That was all on video, and they still got to quit it. All right. So those are the Facebook comments.
Yes.
Okay. All right, let's talk about the gun case real quickly. So we got to go back to the Heller case, the case that held basically that law-abiding American citizens have the right to own firearms for self-defense. All right, that was the Heller case. I think it was Heller versus the District of Columbia. And so this case is similar to that case, and it essentially, let me put it back on the screen. This case essentially clarifies some of the things that were said in the Heller case. The Heller case was written by, the Heller case was written by the late Justice Antonin Scalia. And in addition to the majority holding that law-abiding Americans have the right to own firearms for self-defense without being associated with the militia, the court also said that states still have the right to regulate who can own a firearm, where you can take a firearm, etc. So this case, this Bruin case, basically sought out to clarify some of that. Because in the state of New York, it is very, very difficult to own a firearm. You got to get a license to own a firearm. Even after the Heller case, you got to get you got to fill out an application. You got to prove that you got good morals. You got to prove that you don't have a criminal record. And this was the very problematic part. You also got to prove that you have a particular need to own a firearm. In other words, just stating on your application that you need your firearm for just general self-defense purposes was not enough. You had to show perhaps that you got robbed, or somebody is stalking you, or somebody broke into your house, some special need reason to own a firearm for protection. And that was for inside your house. It was even more difficult if you wanted to carry your firearm outside your house. Okay? So the court said, that violates our opinion in Heller, which basically says again that the Second Amendment protects people's rights, law-abiding citizens, to own guns for self-defense. And the court clarified and said basically that includes carrying concealed firearms outside the home, not just inside the home, but outside the home as well. So that is the basis of this Bruin case, of this Second Amendment case.
I know that's a big change for New York because of how restrictive their gun laws have been. You know, you grew up in New York, Dad, in the 80s, and you know how much gun violence there was and the crime.
I wouldn't say I grew up there. I would say I spent a couple of years there as a teenager.
Spent a couple of years.
Yeah, I'm a country
spent
boy.
A portion of your teenage years in New York.
Yeah. I'm straight country.
So they went on the other end.
Although I love me some New York. I love me some New York, man. I probably would be living there right now. I love some New York. And my mom and sisters and nieces and nephews, and got, cousins and everybody, I was born in New York too, actually. But go ahead, I'm sorry.
But yeah, so just saying, New York went completely on the other end with a lot of the gun laws, the gun prevention, gun control. So the Supreme Court has just now come and has just loosened some of those restrictive gun laws in New York, which is interesting. It's just this super majority conservative court making all of these decisions on all ends of the spectrum.
Well, what about the ramifications of this case and the ramifications of all our cases that we've discussed today, especially as it relates to African Americans, because that's our focus, Chloe. So we know New York is heavily populated. It's an urban area. Some parts of it is an urban jungle. It's some parts of it is really ghetto, and other parts are really, really affluent. But, especially during the 70s and 80s, during the crack cocaine epidemic and the heroin epidemic, I mean, there was a lot of crime, a lot of violence. And I suppose, especially the New York City area, the outer parts of New York are nowhere near that. But the 5 boroughs, I suppose they felt like, hey, we need to try our level best to keep guns out of the hands of criminals. It's just that the court said, yeah, but you're going too far with it. You're not just keeping guns out the hands of criminals. You're keeping guns out of the hands of law-abiding citizens and interfering with their right to protect themselves against the criminals.
Yeah. That's a good point. So it's probably a good thing for the Black people who live in New York to have more access to firearms to be able to protect themselves, as well as any criminals who might get their hands on it as well. So with gun control, I'm typically less. I don't know. I'm definitely more center right on the gun control issue, because I do believe there needs to be less gun control, especially from an African American perspective. We need to have access to firearms to protect ourselves. But in terms of what happened in Uvalde or here in Dallas, I do believe there needs to be more provisions to control who has access to the guns in terms of criminals or the mentally ill. And I saw that President Biden, I didn't read into this a lot, but I saw that he signed some legislation this morning, actually, right?
Yep. I think it was this morning or yesterday. Between yesterday and this morning.
Yeah. So
I mean, that's a great point. So while the court was handing out this case, Congress and the president were signing into law some gun restriction laws. And I looked at it and I like it. I like what they did. It's just that with this six conservative majority, you can kind of already know what's going to happen. The law, what Joe Biden signed into law, somebody's going to sue over it and get it back in front of the court. And the court is subject to strike down whatever they did. I think what is especially problematic to a lot of conservatives are the red flag laws. Okay, the red flag laws I like because what they enable people to do is file a motion with a judge and say, this loved one or this person or this my ex-husband or girlfriend, has a gun and they're dangerous. So I'd like for you to temporarily take that gun from them. If someone had done that with that Uvalde dude and the other dude who murdered the people in Buffalo, that could have spared some lives potentially.
Yeah.
But conservatives are concerned that those red flag laws can just be taken too far and people's due process rights violated. You and I have represented divorced folks, and imagine a divorced wife or husband wanting to get back at the other one and files a motion under the red flag provision and say, "Hey, I'm gonna get rid of your guns. That's what I'm gonna do," and file a motion to say, "Judge, he threatened me. He pulled his gun on me. I think he has a mental health issue. Can you please take his guns from him? And the judge, without having a hearing, without, any evidence, just says, okay, yeah, here's the order. Go get his gun. The conservatives are concerned about that.
I mean, which is a valid concern.
Well, you and I know it can be a valid concern because we represent some of these people, right? We know how they try to use the court system against each other.
Yeah. But I don't think it justifies not doing it in the greater good, the greater scheme of things either.
I agree with that. I think red flag laws are great, actually.
Yeah. Me too.
So more comments. Yes. Connie Cachette. Not easy times in the USA. I'm sorry. Yes, we are. Yeah. No, you're absolutely right, Connie. Things are, crazy here, for lack of a better word. Dangerous. Economics and everything else. Past couple of years have just thrown our country in whack. But we'll get through it.
I'm
an optimist.
Me too. I'm a half glass full type of person, so we'll figure it out. And I mean, America is so young. We're what, 400 years, 450, 100 years old compared to Europe and Africa and South America. So we're still working out through some issues.
Yep, that's right. So No asked the question, Chloe, anyone happen to know if there have been any studies focused on finding at what point in the process of gun ownership do legal guns fall in the hands of criminals? I don't have any specific information about that, but it happens a lot. Intentionally, it happens because there are a lot of straw purchasers. These are people who go and buy guns for the express purpose of selling them or even gifting them to criminals. That is a big problem from what I understand, a city like Chicago, where there are a lot of murders, and Chicago has pretty restrictive gun laws, yet a bunch of guns are in the city of Chicago, especially the west and south side. And what happens is straw purchasers cross the state line. I think a lot of times in Indiana, where the gun laws are much less restrictive, buy bunches and bunches and bunches of guns and bring them back, and they end up in the hands of criminals. Which, by the way, straw purchases are illegal. Those are federal crimes. So anyone who gets caught doing that is facing some serious crime. But it happens all the time. I don't know of any particular studies. I'm sure they're all over Google. But it is a serious problem. One of the things that could help combat that, not only straw purchase laws, but universal background checks. I'm a strong Second Amendment defender, quite frankly. I mean, I think you all know that. I've said it numerous times. But I'm also strongly in favor of doing whatever is necessary to try to keep guns out of criminals' hands, out of dangerous people's hands. And so I favor universal background check. Although, as Chloe said earlier, if anyone in this country, in my opinion, needs to be armed, it needs to be African Americans, because we have, throughout our stay here, throughout our tenure here, have been targeted by extremists and white supremacists and racists. And it wasn't many years ago that we could not own a gun despite the Second Amendment. And we only need to think about Buffalo, and Charleston, to know that we are targeted quite often, even in the sanctity of our churches, our beds, the grocery stores. People just out of racial hatred and animosity and all of that just say, okay, I'm just going to go and kill a bunch of black people. And unfortunately, we're also victims of black on black crime. So I just don't think it makes sense for black Americans to be the only ones in the country that are disarmed. I believe we should be armed and informed.
And they should check out that channel.
That's my rant.
Yes.
That's my Second Amendment rant.
Check out our other YouTube channel, Armed and Informed. And we made a course about it too. I'm sure we've mentioned it a few times, previewing that course that we created called Armed and Informed. Now it's based on Texas and federal law. So it may not be helpful for some people who live outside of Texas, but if you do live in Texas, we'll let you know when we make that available.
Yes. 2 more comments and then we're going to get off. No None says, I would be interested in a study like that than laws created specifically to target that weak point. Yeah, again, there are straw purchases laws that are already a part of the federal regulatory gun buying scheme. It's just that straw purchasers are criminals and criminals don't obey the law. So even if we pass more laws targeting that area, again, it still may not reduce gun violence the way we want because the criminals are going to continue being criminals.
Yep.
Now, let me say this, and this goes to a comment my wife made, which is, doesn't the new gun law passed by Congress attempt to reduce the gun trafficking and requires more gun sellers to register as gun dealers? Now, no known, that is a good point my wife just made. This most recent batch of gun laws could get at some of that because these straw purchasers, they purchase the guns quite often legally at gun shows. And they do so by avoiding the federal firearm licensees, the people who are required to do background checks. They buy them at these gun shows from people who are not required to do background checks. If you don't have a federal firearm license, you're not required to do a background check. So my wife points out that some provisions of this latest legislation requires that more people be required to conduct background checks. So that would get at this weak point that No Known is pointing out. All right. So that's going to about do it. Connie says, thank you for explaining this. Yes, absolutely. That's why we're here. And thank you all for coming.
Yes, we appreciate it. Thank you.
Yes. Chloe, you can close us out. I just want to tell everybody to make sure you go to the channel and you watch some of the other videos that we got.
Yes. Thank you for tuning in and being a part of this discussion today. There are changing times in America, and the Supreme Court has come out with decisions that are going to impact all of us on various levels. So continue to be plugged in with us, plugged in with our channel. We're going to continue bringing this news, this trending politics, policies, personalities, and pop culture from a Black perspective, and continue giving informed and knowledgeable information and analysis So we appreciate you joining us this Saturday, and those who are going to watch after this broadcast. We appreciate all of you all, and we hope that you all have a blessed rest of your weekend.
Let me jump in and say one thing, Chloe. Tomorrow evening at 7 p.m. Central Standard Time, financial guru, financial advisor Sean Durrell, one of the best in the business, has set aside some time to do a Facebook and YouTube live session with us to offer some tips and suggestions on how to deal with the pain at the pump and the pain at the grocery store. You know, the inflation and the high prices. You know, if you're like me, you're not happy spending $250 on groceries and getting 4 bags of a little bit of nothing. And the other day I filled the tank up and it was almost $100, almost $5 a gallon. I've never seen it. My poor father, who was a poor, hardworking man, is probably rolling over in his grave, because I can remember when I was a kid, gasoline was 59 cents, 69 cents. And when it went over $1, I mean, he complained to I don't know where. Now, $5 a gallon in Texas, $6 and $7 in other places. Well, Sean Durrell is going to talk to us about some things, some tips that we can do with our finances to try to help with this pain. And also Monday at 7 p.m. Eastern Standard Time, we're going to have a conversation with a bishop, a preacher, about racial justice and the church, Christianity, and racial justice, because there's so much being said about white evangelicals and black evangelicals and how can they support Trump and all of this. We're going to talk about it. That is Monday at 7. I think it's Eastern Standard Time, so it'll be 6 Central Standard Time. And tomorrow evening at 7 Central Standard Time, Sean, the financial guru, I call him the Black Dave Ramsey. Or really, yes. Or Dave Ramsey is the white Sean Durrell. But I'm just so excited to have Sean. He's going to be with us tomorrow. So you all please tune in tomorrow. If you're busy, watch the replay. Again, thank you for tuning in. And I guess that's it. Peace.
Thank you, everyone.
Love. Soul.
Peace.